Hi everyone, how are you? I hope you're all doing well. I have just a little video to do here to let you know that I was wrong. Yes, people live for this. I was wrong. I had assumed improperly that Katie Joy's lawyers had packed up, left the country, or joined the witness protection program because they cannot control their client. It's pretty clear. When you are in litigation, you are served that there's a problem with your behavior in civil court. In civil court, they're saying, okay, there's a problem with your behavior that has cost somebody their their income, that you have harmed somebody financially. Okay, in criminal, then of course that's different, in that you have harmed somebody physically. So in civil court, we're talking about damages. So they're looking at that particular behavior that has caused the damages, and they're looking at that. And so essentially, a good client would understand with their attorney that the behavior cited in the civil suit needs to be evaluated, essentially frozen in time, and not added to or continued upon. That this behavior cited and that has an action on it, you would want to be really well behaved from there on and not continue that behavior until and if a court evaluates whether or not what you have done has indeed caused these damages. So it's not so much, I hear the words where a lot of people say that there's a gag order on her and that she's violating a gag order. It's not. There's not a gag order. That's not true. It's just common sense, and it's practiced to not discuss that behavior that is under a microscope. Essentially, you want to be on your best behavior and not continuing to add to the concerns that are brought before a judge. So while we see Katie Joy continuing these actions and continuing to add inflammatory I don't even know what to call it at this point. When her attorney wrote her defense and basically outlined what they were going to do for the documentary, her attorney specifically cited that Katie Joy holds no malice towards Robert Shinn in particular. She holds no malice, rather that her research is done for information and awareness. And I think that the behavior recently from Katie Joy contradicts that. And so if I were her attorney and I took that approach in defending what she was saying, that this is not malicious, I would have a very difficult time continuing to work with my client in saying, hey, look, we need to show that this is not malicious, that your intent was not to cause them monetary loss as is accused. And again, it's just good practice where you say no comment, you don't comment on litigation. So I don't know what the hell she's doing. I don't think that I would be very comfortable with my client at this point. I have commented on in the past that I was in civil litigation where I was the plaintiff in all of them, of course, and I would never have commented on what was being taken to the point of a civil litigation, even though I was the one on the filing point. I was not in need of defending myself, but I also did not continue any conversations about what was going on as it was being presented to a judge to determine. In that, I can say that there were reporters interested in my story and the lawsuits in which I had go ongoing, and I would approach each one. I would call my attorney and say, hey, I've been asked to give an interview here, or to participate in this radio broadcast, etc., etc. Do you have a problem with that? And 9 times out of 10, he would just say that, he'll just be there for it. And we made, sure each that, hey, these things we can't talk about, but we can talk about things in a broad spectrum of why we believe that this law is relevant to this case. And that's what you speak to. You speak to the general topic, and you stay away from the person or people or the companies in which you are in litigation. You just simply don't do what Katie Joy is doing. And I think that one of the most egregious things that I've just seen was when she posted that she said, oh, I guess Shinn has gotten the letter from my attorney and taken down what he had stated or faced sanctions. And I had a problem with that because there was nothing showing in the Register of Actions that there had been any new motions. And I was curious, of course, not naive to the fact that attorneys do talk behind the scenes. But when Amber made the announcement yesterday that she needs an extension due to her battling for her life, quite frankly, that she said, in a sense, that the other side was not answering her emails as she was asking for extensions due to her situation. That showed me that there was no email. That showed me that I'm correct in looking at the Register of Actions, because if somebody was threatening sanctions, that would be threatening sanctions at Robert Shinn, who is not on trial here, not facing litigation. Katie Joy is the problem in this, that if anybody threatens sanctions, it goes to her side in this lawsuit because she is the defendant. So those things that she's saying are very, very much not true. Of course, there could be some weird circumstance, and if she wants to provide the receipts of her attorney threatening Robert Shinn with sanctions, I would love to see a copy of it. But for right now, I just don't see that's based in truth. But I do have something that was filed today of note that I'd like to narrate to you. This is from Jennifer Moore. We know that in the beginning it was Graham and Moore, but once Graham was threatened with sanctions once, he looks like he kind of gave this big pile of esteeming horse crap to Jennifer Moore, as she is much more of that mothering, grandmotherly school principal type that seems to take an approach with Katie in maybe a very nurturing. I see her as a very nurturing person that cannot, no matter how nice she is, she cannot be very happy with her client. So I have this footage here of where I was at recently at the Wright County Justice Center, and we'll put that up there just because, I just sit there. That's all I do in my life. I just sit there at the courthouse, right? So that'll be playing as we go. Let's take the volume off of that, and I will narrate as we go here. Let's do this in very slow speed. And give you something to look at. Okay, so what we have here is from June 14th, 2024, submitted via Odyssey, e-file, and e-service, and it is to the Honorable Carrie Willis at the Wright County District Center, and it is regarding the remaining discovery disputes, and this in the 7M, including ET.al, with Catherine Mansky-Paulson, in that court file 86, TAC CV, TAC 22, TAC 1722. And Jennifer Moore begins with, Dear Why did that stop? Hold on. Hold, please. It's not what I wanted to do. It's just not. What happened here? I am so challenged. I mean, I think that that's quite obvious here. I'm challenged. I am very, very challenged. Let's get back in here. I apologize for the technical difficulties. I was trying to be really cool. There we go. Slow that down. There we are. Okay. Dear Judge Willis, I am in receipt of Ms. Stavik's request to extend the deadlines in this matter. Counsel have conferred and have agreed upon various dates for plaintiff's depositions, which are now noticed in late July 2024. There is a dispute as to whether counsel will accept service for two individuals identified in her initial disclosures as being available through her and who appear to be either employees of 7M or doing substantial work that would be done by an employee. Okay. To the extent that plaintiff does not seek to continue these depositions, I do not object to the deadline extensions requested by Ms. Stavik. However, I do request that the court schedule a status conference sometime in very late July or early August to discuss the issue outlined above. I do not object to this conference being telephonic, although I do object to a video conference since there is a history of third parties illegally streaming proceedings in this case. Very truly yours, Jennifer Moore. Okay, so we have something here. We have that there are new players that Jennifer Moore is asking who they are. I saw a new name come across one of the documents yesterday. And that was when I was looking through the Register of Actions. And I am still trying to figure out who that is. That may be one of who she is referring to. The video conference in the past, there were so many people trying to listen in that it was a problem. And then indeed there was one creator, I believe he was an attorney, who was illegally streaming it. I am not sure on the specifics of how that all went. You guys probably know that better than I. It's interesting because there are a lot of people watching this, as we know that social media is a platform that is allowing defamation to cause more damage than it ever could have previously in just our everyday society. I'm very interested in it. As I say, I think that any case right now with YouTube and social media coming to this need to go in front of a judge in court, I think that there is going to be established case law and very possibly going to the Supreme Court in really explaining better about how freedom of speech does not mean that you are able to say anything that you want without consequence. Sure, you can say whatever you want, but there could be a consequence. And that's the problem here. You're not just able to say whatever you want whenever you want. There are consequences, and there could be very big consequences for Katie Joy at this point. And perhaps her perhaps her line of thinking is that she's done what she's done. She's going to continue what she's doing. I don't know. If I were in her position, I would be not commenting on this case or anything with it. And I'm sure that her attorneys have advised her as such, but she is who she is and she will do what she wants, apparently. So, nope, her attorneys are still around. They haven't ran off like I suspected. And that's all I have to say. I will continue to update you when anything happens, if I see anything new. This point in which Jennifer Moore is asking for another scheduling conference is interesting to me, as that was already stated and concluded in the last scheduling conference, and where each side kind of came together, and then the judge said something different, made a different ruling than what was agreed upon orally. And so I don't know why there would need to be another one when it's laid out that basically the judge wants everything in this case wrapped up by the end of the year. That means that if it needs to go to trial, then that's where everything would be ended, that everything should be wrapped up, that there has been attempts for mediation, and that if this continues into 2025, then it should just be, okay, we're moving towards a trial schedule, that everything else that has been done outside of planning the outline and timeline for a trial is done. So I don't know what would change. Obviously, with Amber's very, very sad situation, then things have been put on the back burner, as our health is something we can never take for granted. And again, I hope that if prayer isn't your thing, I hope that you're just sending some positive energy, no matter how we feel about something trivial going on in the court. The fight for your health in the battle with cancer, especially, is of paramount importance. Nothing else matters. And I think that both sides can agree to that and send positive energy so that these issues can be looked at in the future. Nothing's going anywhere here. So thanks for listening, as always, and I will continue to update you as anything comes up. Thank you.